Welcome to another explainer. Today, we're jumping right into a landmark 2003 South African constitutional court case. It sits right at that fascinating, and honestly, sometimes kind of messy, intersection of family, biology, and the law. This is the story of J and B. It's a case that challenged some incredibly rigid definitions of parenthood and forced the legal system to confront its own massive blind spots. So let's get into it. So what happens when biology and love create a family, but the law literally refuses to see it? I mean, imagine navigating a legal system that flat out ignores the reality of your day-to-day life. You have kids, you're raising them, you love them, but on paper, to the government, one of you just doesn't exist as a parent. That bureaucratic nightmare is exactly the dilemma we're breaking down today. It's a situation that forces us to ask, what really makes a parent a parent? Is it biology, intent, or is it just a checkbox on a government form?
Section 1. A family in limbo.
Okay, to really understand this conflict, we gotta look at where it all started. J and B had been in a committed, same-sex life partnership since 1995. After years of building a life and a home together, they decided it was time to start a family. In August 2001, through artificial insemination, they welcomed a beautiful twin boy and girl into the world. Now, this should have been the absolute happiest moment of their lives, right? But when it came time to do the most basic parental task, registering the births at the local office, they hit a massive legal wall. And this wall didn't just delay a certificate, it actively denied their family's existence. This ultimately forced them to initiate a challenge in the Durban High Court in 2002. Now, here's the biological reality. There were two biological contributors to these twins. The birth mother, B, carried them. Her partner, J, was the ova donor. The sperm came from an anonymous male donor. So biologically, practically, and functionally, J and B were both parents. They both brought these children into the world. But the bureaucratic forms under the Births and Deaths Registration Act? Well, they acted kind of like a clueless bouncer at a very exclusive, outdated club. The forms only allowed for one male and one female parent. The piece of paper literally had no blank space, no little boxes to check for two mothers. Because, of course, a government form from decades past couldn't possibly fathom a reality outside its narrow little margins.
Moving on to our next section, the Unconstitutional Status Act.
You see, this roadblock for J and B wasn't just a typo on a form or some lazy oversight by a clerk having a bad day. It was deeply rooted in the statutory law of the time. Specifically, Section 5 of the Children's Status Act of 1987. This section dealt directly with the status of children conceived by artificial insemination. And the fundamental issue here is that laws written decades ago can knowingly or unknowingly ruin lives today because their language is completely trapped in the past. This act inherently discriminated against J and B because it was written exclusively for heterosexual marriages. It essentially dictated that if a married woman had a child via artificial insemination with her husband's consent, the child was legitimate and they were both parents. But for permanent same-sex life partners, it offered absolutely zero recognition. It was as if they didn't exist.
Okay, before tackling this massive constitutional question, the High Court made a really important procedural move. They appointed an advocate, Advocate A. Gabriel, as the curatrix ad litem. In simple legal terms, because children can't legally represent themselves or, hire a lawyer in complex constitutional litigation, a court appoints a dedicated professional to act as their voice. Think of it as a fiercely protective guardian whose sole job is to ensure the twins' best interests are strictly protected and advocated for throughout the whole process. And this aligns perfectly with the South African Constitution's golden rule. In any matter concerning a child, the child's best interests are of paramount importance.
All right, next up, fixing the broken law.
So, with the kids' interests protected, the courts had to figure out how to actually fix this broken law. And this is where the mechanics of constitutional law get incredibly fascinating. When a law is unconstitutional, the courts don't always just throw the whole thing in the trash. Sometimes they act as aggressive copy editors. First, the High Court used a legal remedy called striking out. Imagine a judge taking a metaphorical, thick red marker to Section 5 and surgically crossing out the word married everywhere it appeared. In one fell swoop, just by deleting that single word, it changed the text from applying only to a married woman to applying to any woman.
But as you might guess, just striking out the word married wasn't quite enough to fully fix the discrimination. The law still only mentioned a husband. So next, using a really powerful, albeit somewhat controversial, constitutional technique called reading in, the judge injected brand new language directly into the statute. They added the phrase, or permanent same-sex life partner, right next to the word husband. It's kind of like judicial Mad Libs, but instead of making a funny story, it has profound human rights implications. This 1-2 punch of striking out the bad and reading in the good instantly cured the discriminatory exclusion. With a few judicial edits, the law suddenly caught up with reality, finally allowing J to be legally recognized.
Which brings us to Section 3, the government's counterarguments.
Now here's the twist. You think the government would fight this, right? Actually, when the High Court's ruling went up to the Constitutional Court for final confirmation, the government, specifically the Department of Home Affairs, admitted the law was discriminatory. They didn't even fight that core fact. Instead, they asked for 2 specific things. First, they argued that the court's copy edits shouldn't just apply to same-sex partners. They felt it should be broadened to include unmarried heterosexual permanent life partners too. Second, they asked the court to hit pause. They wanted to suspend the order of invalidation for 1 full year to let the legislature draft an entirely new law from scratch, rather than having the judges play editor.
The government's core argument for hitting that pause button was based on a legal concept called a lacuna. Now, a lacuna is essentially a chaotic gap, a void, or a blank space in the law. The government argued that if you strike down parts of a law without giving Parliament time to write a replacement, you create a massive legal black hole. Imagine adoptions, birth registrations, and custody rights suddenly having absolutely no governing rules for an entire year. That's the kind of disruption to the administration of justice they were warning about, and why they begged the court for that 1-year grace period.
Let's look at the final judgment. In March 2003, Justice Goldstone delivered the final judgment for the Constitutional Court, and he systematically dismantled the government's counterarguments one by one. First, he rejected the request to add unmarried heterosexuals to the law's edit. Why? Well, because that simply wasn't the specific case before them. Making that kind of sweeping leap would mean the court was intruding way too far into Parliament's territory through the back door. Judges are there to judge the case at hand, not to rewrite entire codes of family law. He also flat-out refused the 1-year suspension. His reasoning was wonderfully elegant. Because the court had just used the reading-in technique to actively write in a fix, there was no chaotic gap, no lacuna left behind. The law was whole again. It was just fairer. So suspending the order and denying J and B their immediate rights as a family made absolutely no sense.
So, Justice Goldstone finalized the remedies. He confirmed the High Court's findings, officially struck out the word married, and read in or permanent same-sex life partner. But he also did a little bit of legal housekeeping called a consequential severance. Basically, there was a confusing leftover clause in the law about a child being legitimate as if the gametes of that woman and her husband were used. Now, in a same-sex partnership, applying that literal biological assumption is confusing, unnecessary, and frankly scientifically impossible. It was just dead weight in the text. By tidying this up and severing that useless phrase, the court provided an immediate, elegant solution to legitimize J and B as the legal parents of their twins. Oh, and they awarded them their legal costs for having to fight this battle in the first place.
Relying on previous case law involving same-sex adoption, the Constitutional Court drew a hard line in the sand. They stated unequivocally that our Constitution requires that unfairly discriminatory treatment of such relationships cease, period. The state has a fundamental duty to respect and protect all families. This ruling recognized the complex, valuable, and multifaceted nature of the relationships between parents and children, completely regardless of sexual orientation. It firmly affirmed that families are built on love, commitment, and care, not just traditional molds.
While this explainer highlights a massive, life-changing victory for J and B, it definitely leaves us with a lingering, powerful question to think about. When fixing a broken society and outdated statutes, exactly where should the courts stop editing the law, and where should the legislature begin writing new ones? Justice Goldstone himself noted that piecemeal relief by the courts isn't ideal. Comprehensive legislation from Parliament is always the ultimate goal. But until that happens, this case is a powerful reminder that the courts have the tools and the constitutional mandate to ensure love and biology aren't erased by bad law. Thanks for joining me on this explainer, and keep questioning the systems around you.